States goes bankrupt. The lawyer's secret oath? An expose on the legal fraud perpetrated on all Americans. The courts recognize only two classes of people in the United States today: debtors and creditors. Which are you? The concept of debtors and creditors is very important to understand. Every legal action where you are brought before the court, e.g. traffic ticket, property dispute or permits, income tax, credit cards, bank loans or anything else government might dream up to charge you, where you find yourself in front of a court. It is an equity court, administrating commercial law. Having a debtor-creditor law is the controlling law. Today, we have an equity court, but not an equity court as defined by the Constitution of the United States or any other legal documents before 1938. All the courts of this once great land have been changed, starting with the Supreme Court decision of 1938 in Erie v. Tompkins. I'll give you background which led to this decision. There is a terrible fraud being perpetrated on all Americans. Please understand that this fraud is a 24-hour, 7 days a week, year after year continuous fraud. This fraud is constantly upon you all your life. It doesn't just happen once in a while. This fraud is perpetually and incessantly upon you and your family. U.S. Incorporated. Goes to Geneva 1930s. In order for you to understand just how this fraud works, you need to know the history of its inception. It goes like this. From 1928 to 1932 there were 5 years of Geneva Conventions. The nations of the world met in Geneva, Switzerland for 5 continuous years in order to set up what would be the policy of all the participating countries. During the year of 1930 the US, Great Britain, France, Germany, Italy, Spain, Portugal etc. all declared bankruptcy. If you try to look up the 1930 minutes, you will not find them because they don't publish this particular volume. If you try to find the 1930 volume which contains the minutes of what happened, you will probably not find it. This volume has been pulled out of circulation or is hidden in the library and is very hard to find. This volume contains the evidence of the bankruptcy. Going into 1932, they stopped meeting in Geneva. In 1932 Franklin Roosevelt came into power as President of the United States. Roosevelt's job was to put into place and administer the bankruptcy that had been declared 2 years earlier. The corporate government needed a key Supreme Court decision. The corporate United States government had to have a legal case on the books to set the stage for recognizing, implementing and supporting the bankruptcy. Now this doesn't mean the bankruptcy wasn't implemented before 1938 with the Erie vs. Tompkins decision. The bankruptcy started in 1930 to 1931. The bankruptcy definitely started when Roosevelt came into office. He was sworn in during the month of January, 1933. He started right away in the bankruptcy with what is known as the banking holiday, and proceeded in pulling the gold coin out of circulation. That was the beginning of the corporate United States public policy for bankruptcy. Executive Orders 6073, 6102, 6111 and Executive Order 6260 inches Trading with the Enemy Act. Roosevelt stacks Supreme Court. It is a known historical fact that during 1933 and 1937 to 1938, there was a big fight between Roosevelt and the Supreme Court justices. Roosevelt tried to stack the Supreme Court with a bunch of his pals. Roosevelt tried to enlarge the number of justices and he tried to change the slant of the justices. The corporate United States had to have one Supreme Court case which would support their bankruptcy problem. There was resistance to Roosevelt's court stacking efforts. Some of the justices tried to warn us that Roosevelt was tampering with the law and with the courts. Roosevelt was trying to see to it that prior decisions of the court were overturned. He was trying to bring in a new order, a new procedure for the law of the land. The corporate United States goes bankrupt. A bankruptcy case was needed on the books to legitimize the fact that the corporate U.S. had already declared bankruptcy. This bankruptcy was effectuated by compact that the corporate several states had with the corporate government corporate capital of the several corporate states. This compact tied the corporate several states to corporate Washington, D.C., the headquarters of the corporation called the United States. Since the United States Corporation, having established its headquarters within the District of Columbia,